me is my boss, James. Say hello, James.
Hello.
Uh, and the topic for today's Lawyer and Friends is extreme hardship, or just mundane kind. So before we get into this, as you know, this is attorney advertising uh, purposes. Past results do not guarantee future outcomes. And as always, if you have any questions on a specific case, we're more than happy to take your call and discuss it. So with that said, let the credits roll.
Don't go crazy when the judges who claim it had a good day, when things look hazy, 'cause there's nothing left of 25A. Don't get angry, get mad today. We're gonna help you through it all, 'cause you, my friends, are beautiful. We're gonna get you through it all.
There we go. So the first and most important question is, what is extreme hardship? And the broadest way that we can think of discussing this is as defined in section 35.3, and it's basically it's a safety net. And so when the board and its, not the board, but the courts and its finite wisdom, not the courts, legislature rather, in its finite wisdom, went and reconfigured the comp system in 2007, they went and instituted caps on indemnity benefits, although the court has been doing its damnedest lately to try to countermand all of that. The idea being, okay, we'll increase awards that are payable by increasing the applicable statutory maximum rate, but we'll cap them so it kind of in some ways balances things out. We don't have people lounging on the system forever, and all good things, right? But sometimes you run into a situation where someone really is like very, very ridiculously disabled. And so it doesn't make sense to have their benefits capped. And so that was kind of the, the line that got fed to everybody. And so the safety net provision came into place. The exact language as quoted here, extreme hardship determination applies to cases where claimant's loss of wage earning capacity is greater than 75. It used to be greater than 80, but they went and redid that. And so a claimant may request, it's not automatic, within a year prior to the scheduled exhaustion of their indemnity benefits, that they reclassify the claimant with a permanent total disability or total industrial disability due to factors reflecting extreme hardship. But then they did what legislature often does and didn't go and define their terms. So.
Right, and Brian, I'm just going to jump in and say when this came out, I have some background in bankruptcy, and that phrase "extreme hardship" is used in a bankruptcy context, and there's tons of case law and definitions on it. It's typically used for the discharge of student loans, which, as we all know, student loans are really not dischargeable from bankruptcy, period, because the bankruptcy court's determination is it doesn't matter that you can't pay for it, you undertook the obligation. So, if you can't get that done, it was originally our thought was that this was just not a thing, but it turns out it might be a thing, right, Brian?
I mean, way to give spoilers, but realistically though, as James was saying, like, okay, one place in another kind of law, is this theory of an extreme hardship brought up, and realistically nowhere else, and almost solely for James, because I know he's a big procedural Supreme Court nerd, the ever-present "I know it when I see it" standard, like for obscenity. It's like, yeah, I mean, I can probably go on and try to, give chapter and verse on what it might be or could be, but realistically, when it comes down to it, I know it when I see it. And I think that's what the board or the court was trying to legislature. Third time's a charm again. Might be giving them too much credit in terms of not defining that term, but realistically, they just create a gigantic conundrum for all of us. So there are obviously some requirements, and the board issued, I think 2017, a subject number, setting forth what a claimant actually needs to have in order to be considered to have extreme hardship case reopened, and that's to have a classification greater than 75%. So exactly 75%. Nope. you actually have to be receiving benefits. And one of the interesting things from my standpoint is it doesn't say what kind of benefits. So as James, loves to talk about, reduced earnings and how reduced earnings is kind of, in some ways, the key to running down the caps, because, if they have a reduced earnings rate that's less than their cap rate, well then, you're clipping through those weeks and you're paying less for them than you otherwise have to do. But just keep in mind, it says be receiving benefits when we talk about this later. You also have to be within a year of your cap expiry. So could you make this application 2 days before it runs? Yes. A year and 2 days? No. And 2 days after? No. So it's a really wonky and finite term. But also, I like the fact that it's completely prospective, because otherwise, claimants, oh, I forgot to do that. Let me try to get more money. Because, that's classic claimants for it. And you have to complete and file the board's C-35 form within the required time frame. So there's a form, I got a snapshot of it coming up in a little bit. But, logically, because it's talking about lifting the caps, this does not apply to uncapped claims. And so, a claimant can't come back and just say, oh, I'm experiencing extreme hardship. Yeah, but you're getting $400 a week for life. You don't care. Go away. So and here is the magical C-34 or C-35 form in most of its glory. And interestingly enough, they're talking about non-wage household income, which then leads me to believe that, while we still are actually looking at all the income the claimant's getting and their household is getting from all sources, the board's clearly not the best at making forms, because they clearly forgot about that entire tranche of claimants who are working with reduced earnings. But they set for some of the more vague general kinds of income that people could have, both the injured worker, their spouse, and other adults residing with the injured worker. So there's a case coming up where a claimant, not case coming up, but coming up in my little spiel here, where a claimant was living with their adult child who is mentally disabled, and that child's income and benefits were still considered in the claimant's application for extreme hardship. And then they give a very small snippet of living expenses. And anyone who's ever been divorced before knows the New York State 236B affidavit is exhaustive and has all sorts of fun little, how much do you pay for this, how much do you pay for that sort of things, and then has just pages and pages and pages of what are your assets and where are they and what are the amounts and all that stuff, because that the purpose for that is more complete financial disclosure. And as I'll talk about in a little bit, you can have situations where you might have no income and not have any hardship. Do we imagine that Scrooge McDuck, if all of a sudden he just sold all his businesses a year after that, would be like, oh no, I need money because I have this comp claim? Not really so much. And then interestingly, other factors that contribute to an extreme hardship. And as James alluded to earlier, there's been one case out of 21 that have been brought up to the board panel in which the claimant's C-35 form have actually been addressed, that has actually found there to be an extreme hardship. And so, realistically, I think a lot of what this is going to come down to is going to come down to those other factors that contribute to an extreme hardship. James, have you had any extreme hardship cases?
No, I haven't actually. I've worked on teeing them up, but I've never actually had one because they seem to be fairly few and far between.
I've had two, so. But and again, as I was talking about, income from all sources, and just as James has a background in bankruptcy, I have a background in family law, and there, domestic relations law section 240 defines income from all sources incredibly broadly. I've been working on divorce cases in the past where our client's mom was paying their cell phone bill, and that got included as imputed income to them, because it's essentially, hey, you're paying for something that someone doesn't have to otherwise pay for, that counts as income. And so, one of the things that we might try to do in terms of defending these cases going forward is try to go and take a, in-depth and detailed look at, these other kinds of income, such as obviously workers' compensation, just general disability benefits, because some places have, long-term disability and stuff like that, unemployment, how many clinics do we get to try to double dip, Social Security, veterans benefits, pensions and retirement benefits. Given the fact that a lot of the board's analysis is focused on, realistically, what separates this person from any other disabled person? And we all know a lot of claimants don't actually go and save anything, but some people do and some people might. Fellowships and stipends I don't really see as important, because if they're having those and they're working, and chances are if they're doing those things, then they're not really going to be applying for extreme hardship benefits. And other annuity payments. Oftentimes we see people who have third-party actions. Those things can get paid out in annuity benefits. And sometimes people, have things going on in their life outside of workers' compensation. And so because annuity payments would count towards income from all sources, it at least lends them to be open up towards, they ever had any sort of other, personal injury claim. Because if they might be receiving annuity benefits, and that kind of opens them up to vulnerability for questioning on that avenue. All right, 1 second, I had some stuff pop up. My EK is telling me that, oh, you haven't been using it, we're gonna close it down. But another big thing is, as mentioned in the subject number, your C35 has to be complete. And that includes income from all sources and others living in the same household, including the adult children. And I've actually got cases kicked back out when, it's come on for an extreme hardship hearing and it's all set to go and have their testimony, and all of a sudden it's like, Judge, they're claiming expenses we don't have documentation on them. So, this case should be closed until such time as they actually go and produce all that information like they're supposed to in the first instance. Which I really like, considering it's been said more than a time or two that you can win more things on procedure than you can on substantive law. And I'm also a huge proponent of the philosophy that, if they don't prove something, they don't get it. And if the board actually requests and requires you to produce all the documentation to actually, put up or shut up regarding your expenses, that they actually have case law that says, no, we actually meant that. You have the obligation in the first part to give us everything that we wanted for before we go and, kick off this, potential gigantic pain of the litigation. And now we get into extreme hardship. And independent group.
Sorry, I'm just going to say extreme every time. Go ahead, Brian.
James actually wanted me to try to frame this in terms of like the most extreme elimination challenge show from like 10, 15 years ago. But I was like, yeah, that would be really hard because there's a lot of dubbing in that show. But anyways, independent group home was one of the first cases that actually dealt with this, level of extremeness that's required for extreme hardship determination. And an interesting little wrinkle is when the law was initially passed, it was greater than 80%, and then it got changed to greater than 75%. And so one of the issues in this case was, well, when they were classified, they needed to be 80, but then the law changed. And so, yeah, the board doesn't care. It's however they're situated at the time that they make the application, just like when the 25A fund went away. And the board's like, or the court even said, yeah, you don't really have a vested interest in the law not changing. So too bad, so sad. It is what it is now, and so they qualify. But then the thing that I'm not going to lie, I literally just stole from one of my memos on the extreme hardship is this exact quote from the case that I find impressive and telling, and I use it all the time. The legislature clearly did not intend that the standard for reclassification be hardship alone, but rather that a claimant must demonstrate a financial hardship beyond the ordinary and existing in a very high degree. So this kind of is the first lens that this gets framed through in terms of how does this claimant differ from someone else who's just retired? And so the fact that the claimant's expenses exceeded her income, or the fact that she lives in a part of the state that's expensive, aren't factors that are considered in extreme hardship determination. And again, that just makes sense. I mean, my mom's like, she's told me that she can retire now, and honestly, she thinks about it more and more as days pass, because she does 401k implementation, is having to tell people the importance of saving for their retirement, a job you don't like. But, when you retire, I mean, it's a natural thing that your expenses exceed your income, because, in theory, if you are, living off your investments, and, the standard rule of thumb has been for years and years that, if you're using like 5% of the, account balance a year, then you're using stuff that'll pretty much be replaced by further growth of those assets. But what happens when, that's not the case? And for most people, their money just doesn't continue to maintain in perpetuity. They have to, dip into that as inflation tends to, grow and hopefully not outpace the rate of their savings. So, it's very common for people to start out with, say, $800,000 in their, retirement account. And then by the end, it's, 50,000 to be passed around between their kids, because it gets used up. And so the fact that, you're actually spending out more than what you're, currently making in retirement, that's normal. That's standard. That's kind of what we expect. And so the fact that you as a comp claimant, your expenses, oh no, they're greater than what your income is, that's kind of par for the course. One of the things that I also stole from that case, which it's not in quotes, it kind of should be, but that a claimant that is receiving a normal Social Security retirement plus her spouse's retirement income may not be characterized as experiencing a financial hardship beyond what is ordinary, usual, or expected for a retired person living on a fixed income. Because, you're retired, your spouse is retired, why would we expect claimants to be any different? So that's where this analysis kind of started. And honestly, I think that's where it ultimately ends up, juxtaposing the claimant versus a regular retired person. And for the longest time, it was what I used to call the best benefit the board doesn't want the claimants to have. And I was actually toying with the idea of using that as a title for this presentation, because, I mean, it sounds doom and gloom, doesn't it? Caps on the benefits lifted, benefits increase in total rate and continued until they die. Or heck, in some of those other cases, I mean, James, how do you think this will interfere with those cases that get claimants paid out based on their uncaused related deaths?
I don't know. I mean, that's a good point. I mean, can you claim lifetime benefit? I don't know. If they're dead. Oh.
Yeah, well, because as everyone in the know who's been keeping up with our presentations and stuff like that, the third department does not understand realistically how comp works. And so, there are cases now that say, even if the claimant died an unrelated death, oh, yeah, they still are entitled to the payout of like the remaining balance of their capped weeks, which is asinine, as is, the claimant died before they could be awarded schedules, but no, we'll go ahead and still pay that to their estate. Like, no, the entire purpose of...
I would argue, Brian, I'm just thinking about this. I would argue, Brian, that the court's holding in Green v. Dutchess only applies to the benefits that were established at the time of permanency, because they're not actually substituting claimant, right? In those cases, they're just saying that the balance is paid over to the estate. It's not like we're substituting in the estate as the claimant. So maybe once the payout is made under the Green case, there is no more claim because there is no more claimant, right?
I mean, I agree with you there. But at the same time, who knows what claimant's attorneys are going to try to pull in the future, and who knows what the court's going to do, because as we said, they clearly don't understand how comp works.
Mm.
Thankfully, the board does. And there have been some fairly recent decisions that denied extreme hardship in situations that are kind of egregious. Like the first one, Brooklyn's Children's Psychiatric. Oxygen-dependent claimant with unrelated COPD residing with her mentally disabled son. Nope, don't care. Claimant with a 95% LWAC with a comorbid knee condition living with a disabled spouse. Again, not extreme hardship. There's even one claimant with an active pancreatic cancer. I think it was stage 4, and living with a disabled spouse. No, we don't care if your comp benefits are going to run out. And so, I mean, you know, from the sidelines, we have carriers, you know, just basically cheering this. It's like saying, yeah, to quote one of, you know, the more obscure movies when I was growing up, you cannot get this, you cannot get this, la 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 la. But the one time he break a cage and he get this, which brings us to the Finger Lakes DDSO case, which was actually done by a Rochester firm. Hooray. Downside, it was also our best friend, Greg Connors, who litigated this. And honestly, I called him and congratulated him on the win, because this was like a perfect storm of facts, which if the board's not going to go and say this is extreme hardship, nothing is. But at the same time, as we'll get into later, there's a lot of stuff going on here, and a lot of those other cases were pretty extreme too. And so exactly where this is going to fall, in the meantime, who knows? But
did you actually write Paramore on there, Brian?
I did.
I'm going to have to scrub these a little more carefully next time.
Well, again, family law background.
Yeah.
It might not be spouse, because the C-35 just says, other adults that are living with you. I had a case against Larry Lindsay a month and a half ago where the claimant and his live-in girlfriend of 17 years, so if I said spouse, that would be inaccurate.
That's true.
And there is a general term for, when you're in a long-term relationship with someone. But anyways.
All right, well, let's get back to this case.
Sure. In this case, the claimant was receiving multiple forms of assistance. He was getting both Social Security as well as his rent was income-based. He was getting food stamps. So he's getting all sorts of public assistance already. Access VR turned him down because he was too disabled. So just even said, no, we're not going to help you look for work. But even despite that, the claimant went and did a weekly job search since he was classified, right up and through his, testimony being taken. And so by the time that was, taken, between the application being made, between his benefits running out, because at the time of the trial, he made his application before, in that year beforehand, but care suspended when the cap hit. And so he was just left there twiddling his thumbs going, I want you to modify awards, but I'm not getting anything at the time. So what did this guy do? He continued to look for jobs, and he looked for over 100 jobs within that sedentary work capacity that he had, even within the year up into the trial. And so, had a spouse that was also, receiving benefits, and realistically had modest living expenses and would have a notable shortfall without further help, basically. So this, to me, this says this guy is really hard up, and what kind of separates him from so many other claimants is that he actually seems to be trying to do something about it. Now, believe me, I looked, we don't have access to this case, so I don't know how good his job search was, but, the fact that he's at least keeping at it, and, in the light of Access already telling him that he's, no, you're too disabled, we can't help you, at least shows that, when I say to people, and their disability, their hardship was so extreme, they saw it coming for years in advance, and what did they do? Nothing. This guy actually did something about it. And so I think that might be one of the controlling factors going forward that we need to keep an eye on.
Well, you know what, Brian, I just want to sit on that for a second, because one of the examples you gave previously was a woman with 95% LWEC and unrelated COPD. That person couldn't perform a valid job search, period, right? Even if a court was provided with a job search, I think the argument from counsel would be that it wasn't even valid. What work could that person possibly do? So it makes me wonder, like, this is just an interesting, it might be a formula, but I don't want to say that yet. It might be an aberration. I mean, it could very well just be the three commissioners that heard this were particularly liberal.
It might be. And as you said, we have one data point, but
right.
We try to compare and contrast that. And if I put on temporarily my claimant's attorney's hat, I'd say, of course this person's job search is valid. He wasn't found to have a total industrial disability. Are you saying this person couldn't possibly do any other work? Should we reclassify him with a TID now? I think that would be,
yeah, I mean, I guess that would be the application. I mean, but a TID requires something other than just a claim that you can't work. It has very formalistic proofs that have to be made and elements that have to be met. So, I mean, it's almost, I mean, that would be a sideways claim for a TID, bringing it into Section 35 litigation, to say it's extreme hardship because this job search proves the TID. That's not really the purpose, though. I mean, the TID is the result, or maybe the result, but that's not the process that we're looking at, though.
Well, at the same time, that's assuming that A, claimants' attorneys won't take a buckshot approach with this sort of thing, and B, that judges will be nuanced enough to care.
Uh-huh.
I mean, we have some very pro-claimant judges in this state, and would they even really care about the nuances of that argument?
Right.
But as James says, there is a lot to unpack here, so I don't think it's just that one factor. And if anyone's familiar with the show Hannibal, it kind of reminded me of that whole aspect of field kabuki. And for those of you not in the know, show behavioral profiling and the whole shebang. And there was a copycat sort of murder. And so everyone was asking, is this the same guy? And our protagonist was like, no, it's completely different, like in every way. And says at one point to someone else that it's like you had to show me a negative so I can see the positive. So seeing, which of these factors are and aren't important, aren't controlling, that I think in large part will kind of be where things are going forward, and juxtaposing, what was in this case that the board previously didn't care about, so we can look as potentially trying to exclude as we figure out how we're going to deal with this as the situation evolves. So in fact, the criminal had a budget shortfall. That's probably not going to be the case. In Finger Lakes DDSO, there was about $1,500 monthly shortfall of account benefits. But independent group home, it was only $25 a month less. So that's, in the balance of things, that's probably not what the board cares about. Streamlining expenses, I'm sure they helped. There were cases like Westbury Jeep, where they actually went and denied extreme hardship because the claimant could have reduced their expenses, but just didn't care. And so,
I just find it very interesting too, that when we looked at the case that we're discussing, the board just accepted a $225 a month internet and cable bill.
Internet, cable, and phone.
Internet, cable, and phone. Yeah, that seems like a lot to me, doesn't it? I mean, I cut the cable, man. We got rid of it once it's getting up, up to over $200. I mean, I guess, what do claimants have to do when they're sitting at home other than watch television? But I mean, geez.
Library card?
Library card. Those are free. I'm just wondering, I mean, we get to make judgment calls about this stuff, right? I mean, that's basically what you're telling us. We get to be judgmental about the expenses of this person because they're the one making the request for extended durations or indefinite duration of funds.
Well, I'm actually glad you brought up the whole cable phone internet thing, because the claimant in Westbury Jeep had that, but they're also paying for like 3 cell phones. It's like, yeah, but do you really need all this crap? And so the fact is, Westbury Jeep stands for the premise that, we get to actually look at your expenses, not just take them on blind faith. I had a case with NYSIP where, the client was trying to say that, oh, I'm going to have these expenses because we had to move to a place that was less expensive and we have to get it fenced because, we have dogs and my neighbors like threaten to shoot them if they come on their property. And it's like, can't you take your dog out to the bathroom on a leash? Like, come on, be reasonable here. And so, if the person's expenses are reasonable, then, it's not going to automatically be a green light. But if they're not reasonable, then that's something that will definitely stand in the way. In fact, the person was on Social Security in Finger Lakes CDSO. It's actually really weird because unlike independent group home, after the Medicare premium was taken out, this client was only getting $24 a month from Social Security. And I mean, I'm sure, James, when you're reading the decision, they kind of harped on that. They mentioned it like 3 or 4 different times that, oh, and they're only getting $24 a month from Social Security. So,
but I mean, that's an interesting point because that might be that they're on SSI, right? And it might be that this person never actually worked enough in their life to be entitled to an Social Security retirement benefit, right? And if they had a Social Security disability benefit, again, it was so low because their qualification, their pay-in, that after the comp offset, there wasn't much left over.
Yeah, and that probably would be a great argument going forward for us to argue if, in one of our cases, if, because I can't look into that case, so I can't really do that, deep dive that we'd like to. But, at the same time, how much, I'm also curious as to how much of that the board might care about, because, what's that whole idea of the eggshell claimant? We take them as they come. It doesn't matter if they have a pre-existing condition. All that's required is that, their injury acted on it in such a way to create a disability that didn't exist beforehand. And so, then yeah, if the claimant didn't get hurt and didn't, stop working, they might have had more Social Security. But that's kind of not the situation that we dealt with, But it is definitely an argument to try going forward. Some other things. The multiple forms of public assistance really, despite the board, mentioning it, and they mentioned it a couple of times, the Brooklyn Children's Psychiatric case where the claimant lived with their, adult mentally disabled son who got, supplemental Social Security, food stamps, Medicaid, the whole 9 yards. They didn't care. They didn't find, extreme hardship in that situation. But then again, the sample size on all of this is very small. We have a total of 21, situations to look at and try to analyze and try to divine not just what the board's doing, but what they're going to be doing going forward. Because, precedent, stare decisis, the whole shebang. But at the same time, how often have we seen the board go and completely about face among the lines of, case law? So we only have, one other case to look at. So it's probably wasn't, really the thing that did it. And again, the spouse being on Social Security, nope. All 3 of those horrific cases that I, put up there earlier were all cases where they were, living with a disabled person and, having to try to, float this little family unit on, what they were still kind of getting as residual funds from that and some other sources. And the board clearly does not care about this, which then leads me to believe that, kind of circling back to that idea of, okay, your hardship's so extreme, well, what have you done to try to make it? And the quote from the case is, without a continuance of workers' compensation benefits, the claimant's prior testimony and C-35 show that he would experience a notable shortfall in his ability to meet his monthly obligations. And again, his ability to obtain new employment provides that he would have had no means of producing additional income to bridge that gap. So one of the cases against Larry Lindsay a month and a half ago, claimant and his live-in girlfriend of 16 years, he's in you, James, they didn't really share finances. And so the trailer was in his name, some of the other expenses were in her name, but they've been together for longer than most people's marriages, and and yet they have no plans on how to tackle all their high interest credit card debt. Like, oh, their hardship is so extreme. Did they get a consolidation loan? Did they try to put everything over on his credit card that has like 3% interest on balance transfers instead of like the 28% that were on all three of her cards? I mean, with the budget surplus that they would have had between when the claimant filed his C-35 and the hearing, they could have paid off like 80% of that, high interest debt, and they didn't. And so I think having a plan and actually doing things doesn't have to necessarily be, looking for work, but I think the board's going to take a very, very dim view of people just kind of sitting there like slugs going, oh, I don't have to do anything because, I'm going to have a hardship and they're going to give me more money. And that's, to me, that's not what's going to happen. So I think it's going to, be actually looking at, that whole difference between a regular retired person and someone who's about to fall off a financial cliff. So, I mean, I think it was James that was actually kind of busting my chops in our weekly roundtable meeting about that. Because I got into that whole shebang, as well as how, even without the claimant's indemnity benefits, they still would have had a budget surplus in that Larry Lindsay case. And so, like, I mean, we have tons of cases with budget deficits, not extreme hardship. You have a surplus. Literally, just go away.
Well, so, and I mean, just because, I mean, it's going to be more and more common that the ordinary retired person is not going to be able to live and not work, right? I mean, this is just the arc of history, right?
Well, that ends, I mean, the Ponzi scheme at Social Security in general. I mean, when they initially started up, there were 43 payers for every person that was collecting from the system, and now it's 1.2 or something. No, it's 2.5 or so, because that's what happens when you have aging demographics and you're literally running a government-funded Ponzi scheme. Right. As well as the fact that Social Security goes to things other than just retirement, and it's something that people don't really take into consideration. So, a couple strategies that I always kind of teased out going forward with this. One that I think is probably our best bet going forward, I'm calling simulacrum, because the second definition of that in the dictionary is pretty much an inferior copy of something. And when you have all of these really terrible stressed situations, 20 of them that are just kind of varying degrees of crazy, and then one that's just completely over and beyond, it leads you to think, okay, you have to pretty much kick this up into 11th gear. And what this really makes me think of is that scene from Pirates of the Caribbean. It's like, oh, the Black Pearl's not a real ship. It's like, but I've seen it. Oh, so you've seen a ship with black sails that's crewed by the damned and captained by a man so evil that hell itself spat him back out? No. But I have seen a ship with black sails. Oh, and no ship that's not crewed by the damned and captained by a man so evil that hell itself spat him back out could possibly have black sails. No? Oh, see, then it's not a real ship. Because, I mean, there's a lot of things in this case that, make it kind of a unicorn in a lot of ways. Like, oh, Social Security is giving this guy less than, $25 a month, and they were turned down by Access VR for help, and they've continued to look for work. I mean, you show me a claimant that has those three factors, I'll show you that something's, few and far between. And so it's like, oh, yeah, but Social Security's not going to really help him out. Don't care what he's done about it. Or, oh, he's looked for work. Yeah, but, and as James was saying, in terms of like how legit is your job search? I mean, did you just do one of those BS Indeed.com apply for everything, buckshot things that we see unfortunately succeed more often than we'd like? It's like, no, you could have gone to Access VR, you could have got retraining, but you didn't. And so,
and I mean, there's also, I mean, aren't there policy considerations here too, Brian, right? Yeah. I mean, the 2007 reforms were essentially a deal. It was a quid pro quo. The business acceded to increased rates in exchange for time-capped benefits. And plaintiffs' bar acceded to time-capped benefits in exchange for increased weekly benefit rates. This this safety valve is supposed to be sort of an exceptional tool. But if the board starts to permit extreme hardship or waters down its application of this section of the statute and starts to permit more of them, you take that in combination with gutschess lumber, and you take that in combination with the recent case law essentially stemming from Jacoby on post-classification surgeries and post-classification temporary disability. And what you have is that the bargain's been entirely broken.
Yeah, you might as well not have the caps. Go back to lifetime benefits and have fun with your $400 a week.
Yeah, I would bet that if a study was done, costs were probably lower at $400 a week with lifetime benefits than they are right now with $944 a week, and essentially exceptions that appear to be subsuming rules.
Well, and honestly, that's why I love this case, because I mean, true, I'm not necessarily pleased that the bad guys won, no, but this sets just an absolute bonkers level of like how bad your hardship has to be in order to get there. And especially given all those other like bad situations, it really goes and shows how insane the bar for extreme hardship is. And honestly, like, I'm predicting honestly that we're going to have like just a run on these things when anyone who has, their benefits about to expire, it's like, oh, I want more money though. And with a case saying, these 20 situations weren't bad enough, only this one was. So have fun reaching that standard.
Right.
But another thing is previously talked about digging deeper into the financials and unearned income, because take the Scrooge McDuck example. If he's just got like that vault just filled with cash, he'll have no income because it's not invested, so it's not like he's even receiving any dividends. This is a gigantic supply of cash. It doesn't mean that like, wow, he's got a $400,000 a month budget deficit, he must have an extreme hardship. Not if he's got billions of dollars. And I mean, I understand everyone's not Scrooge McDuck, but it does, this idea and this concept does, leave us potentially with a very wide discretion to actually dig into these things. I mean, it's, I'm sure claimants are going to try to balk at this, but it's like, look, you're telling us your financial situation is so dire, so extreme, that despite knowing for 5 years your benefits are going to run out on this date, you need more money. Not you want more money, you need more money. Prove it. You want to see all this stuff. And, the last strategy, while reactive instead of proactive, claimants are lazy. And oftentimes their counsel is too. I mean, they don't tend to be up on the most recent case law because, in the most recent extreme hardship case I did, all the case law basically was saying that the fact that you have your income less than your expenses doesn't mean you have an extreme hardship. And what did claimant's attorney do? Only focus on the money. It's like, claimant's attorneys for too long have had it that they don't actually have to be, up on the case law or, in the trenches nearly as much as CARES attorneys if they want to hope to win. Because, that whole idea of, oh, the humanitarian efforts of the comp system to blah, blah, blah. No, it's a compromise. That's what the system ultimately is. You do your share, we'll do our share. And so now it's claimant's turn to actually put up their share and say, hey, I think I need these things. Not that I want them, not that I'm entitled to them, but I need them. And honestly, I think most of them aren't going to actually go and prove that. Like, aren't even going to come close to the standard that we have from Finger Lakes DDSO, and are probably going to be even less extreme than, the cancer patient, the 95% LEC person on oxygen. And so I think a lot of these are just going to be those, BS, oh, I filed for it protectively, let's have a trial. It's like, no. So, I mean, it could be the situation where, we might be able to even try to get some of these things bounced before trial if, based on a proper, on the facts as documented by the claimant. They don't even have, some sort of, negative cash flow. Because honestly, if you're still making more money than you spend, you don't even have a hardship. That's life. That's paycheck to paycheck, like so many of us do. But, James always has good ideas in terms of how to fight things. But James, am I off base on this?
I think you touched all the points. I mean, a C-35 that's filled out at a bare minimum has got to be rejected as insufficient without documentation of everything, right? That's step one. I mean, step two is coming in with the case law and guns blazing. And I guess step three is finding out, like, what are you doing apart from making this application for more benefits? I mean, I'm still stuck on the idea that this looks a lot more like social welfare than it does like workers' compensation. And it strikes me as the board should be incredibly uncomfortable with this process, because it's all about making subjective judgment calls about somebody's life, their lifestyle. And part of it I find intriguing is that the person who is living in Section 8 housing on food stamps, collecting Social Security disability of almost no amount, the question you have to ask yourself is it so unreasonable to say, like, but for the work accident, that's where they would have been? Or you're probably going to be in the same place because you would have been working at Sunoco or the corner bodega at $10 an hour. I mean, are you actually any different? Are you off any differently, having collected, a disability benefit tax-free for however long, and now you're looking for a lifetime benefit from an insurance company? And, what are the policy implications? We've now, on that case, that carrier on that case lost the entire benefit of the bargain, right? They're not getting, they got no benefit from the 2007 compromise or the reforms in 14 or the reforms in 17. Not a single thing. All they got was a higher rate of pay, which I find just absolutely mind-boggling. And I think we need to litigate files with that attitude. That you shouldn't get this.
And thankfully we're a firm that does. And did you say mind-boggling?
It was mind-boggling. My mind was bottled. All right.
So with that, does anyone have any questions?
Yeah, we should probably unmute everyone, Brian, or if you can type them in the chat.
Trying to.
Oh, Brian, this is Mark. I got a few. Can you hear me?
Hi, Mark. It's really hard to hear you.
I'll try to talk louder. Can you hear me okay?
Come again? Sorry.
Can you hear me okay?
Not really. Could you type it in the chat and Najee can read it to us?
Okay, I'm going to do that.
So while Mark's typing that, does anyone else have any questions? Okay, then I guess we're waiting with bated breath.
Yeah, I'm not sure what was going on there. It sounded like a kind of a bad connection with Mark, but I'm, again, happy to read the question if you put it in the chat.
So also opening up to any of our fellow Lamadians. Who else has handled an extreme hardship case? Unless it's literally the chief stands alone.
In all fairness, Brian, I have been giving you all of the extreme hardship cases. You just never noticed.
Well, I mean, as I said, my mom has worked in investment banking since I was a little kid. And so I've kind of been raised on these sorts of, financial things, as well as, the family law background. So it's like, wow, it's like perfect little wheelhouse sort of thing. It's like, I got scheduled loss and I got this.
Mark, type his question in.
Yes. Mark says that he took the opportunity to get an asset check last year for a cap that is about to expire in 2 years, 90% LWEC. They own a nice house and have 2 nice acres.
Mhm.
Or
Well,
area.
and maybe they are in two nice acres. Yeah, that's more acres than most people have. I guess that
cars.
Oh, cars. That's it.
Oh,
2 nice cars. Yeah,
Sure.
I mean, Mark, that's a spectacular investigation because, you know, to Brian's point, which was sort of simplified into, you know, Scrooge McDuck does not qualify, and taking sort of a more bankruptcy looking aspect, you know, that they have valuable assets probably means that they can't demonstrate extreme hardship. So Mark's question is, what if they suddenly get divorced shortly before the cap expires? Well, I mean, Brian, I guess, you know, in theory, you know, like they're each going to get a car and they're going to sell the house, right? You know, or come up with some kind of compromise to split marital assets. But
that would be a very interesting cross-disciplinary question. But, you know, as Jim said, you either do 2 things with, you know, matrimonial action. You either split it or sell it and split the proceeds. And so, I mean, as the fact pattern was coming out, the first place my brain went to was, okay, I mean, if they're living in a, you know, $350,000 house and, you know, they could just easily sell that and live in a $100,000 house, then boom, they have $250,000 they can use for paying for stuff. That doesn't seem extreme hardship to me. And there's no, you know, there's no reason, no basis that they need to live in that expensive a place. You know, I'm not saying we should condemn everyone to the slums, but when you look at it, it's like, you know, we're pretty much looking at people who are, you know, so kind of hard up that, you know, their need is just so incredibly insane that it would be considered extreme. And, you know, if you're sitting on very easily disposable assets, I don't see how you can get there.
And then the next part of the question, young kids at the time of classification who are college age at the time when the cap expires. So I think the obvious answer is...
are they claiming them on the tax returns?
Yeah, I mean...
If they're claiming them on the tax returns, then anything that those, you know, kids are getting, presumably scholarships, work study, you know, you got an additional job going on, then yeah, that should all be considered towards, you know, the income of the claimant. I mean, hey,
Well,
you're telling the government that, you know, they're your dependent, that they reside with you for the purpose, you know, for tax purposes, because living, you know, away at school doesn't count. So yeah, give me their income information.
But I also think I think the question's getting at, what about paying for college or assisting with paying for college? Like, every parent wants to do that, but not every parent can. It's kind of a luxury, right? I mean, if you polled all of our, even our, you know, like people our age, Brian, our classmates, how many of them were taking the student loans on themselves and working and paying for their school? How many of them had their parents paying for everything, let alone paying for something, or, you know, paying for nothing at all?
Well, actually, there is a case, it didn't deal directly with student loans, but it dealt with a mother who was, you know, socking money away to pay for like her daughter to go to camp. And the board did not consider that in terms of the mother's expenses. They just did. Yeah. So, I mean, it's like, hey, this is, you know, they didn't really address it. They didn't say, hey, screw you. But at the same time, you know, when it then came time for, you know, finding what the parent, you know, what the, you know, mom's expenses were, they noted that and they did not add it in the total. I can't see, you know, college education being any different than summer camp in that, you know, to that extent, because, you know, oh, you know, you have such an extreme hardship that you need the, you know, the carrier and the comp system to, you know, completely bend over backwards and abort all of the benefits, you know, from the bargain for, you know, multiple different iterations of legislative sessions because you don't want your kid to have student loans. No.
Well, and then the last 2 questions are good. It's, you know, what's the mechanism of actually finding it out about assets? How do you actually find the spouse's income, inheritance, et cetera? Can't they hide it? Does the board have any enforcement to order them to produce all financials? Well, the answer to the last question is first, is that they are supposed to produce all that stuff. So demanding copies of bank accounts, particularly the accounts that we know that benefits are being direct deposited or deposited into, would be an obvious choice, you know, directing them to produce that account. The real answer is yes, they can hide it, right? I mean, you can search for assets, but in cases, for example, when you're trying to enforce a judgment, the process for determining assets is largely based on essentially super aggressive subpoenas and debtor depositions. And you're going to go in and you're going to start subpoenaing financial records from banks. You're going to hire private investigators to find out where accounts are. You're going to take sworn depositions from non-parties about, you know, like what assets the target defendant has or doesn't have. You're going to be getting tax returns. Yeah, it's a mess. Is the board equipped intellectually or even authoritatively or jurisdictionally to make that stuff happen? I don't think so. I think right now, by and large, we are relying on the full honesty of the claimant in terms of what assets they have or maybe even income sources. It would not be difficult for, say, a claimant who's injured in their 50s to subsequently inherit an annuity from a deceased parent. And they're collecting an annuity check, and we know nothing about it. And there's no way to know about it apart from getting the tax returns and seeing that income reported on the taxes.
And that's why I think asking for tax returns is something that's incredibly reasonable. I don't see the judge trying to stonewall us from that at all, given the fact that it's it's an amalgamation of all your income information that you're telling the government about. So you've already told people about this. It's not like it's super secret, especially when you're trying to tin cup it from us.
Right.
As well as there doesn't seem to be anything that would prevent us from hiring an investigator to try to dig into some of this stuff.
I think you'd have a fraud claim too. Even if you couldn't find it beforehand, if you found it after, I think you'd have a fraud claim.
Yeah, because their intention was
they made a misrepresentation to obtain benefits to which they'd otherwise not be entitled. I think you'd absolutely have a fraud claim. Kim Snyder asked, when they allege they're using loans and credit cards to pay for everyday expenses, can we request they submit all of the statements and loan applications to support the contention? I think absolutely.
Yeah, I would.
And I think
if they're making payments on their credit cards, they should be submitting at least one statement showing that, okay, I've made this payment, to actually go and document that there.
Yeah.
But also in a 236B affidavit for a divorce, they don't want just one statement, they want a year's worth of statements. Because it also shows, hey, I mean, I can go and pay $1,000 on a credit card and be like, look, this is what I pay every month, because I have one statement that shows it. But is that what you pay every month? I want proof of that.
James, can you guys hear me?
Yep.
Yes.
Yeah, we just had that case on. We have to actually, Erica actually has to write a memo on it. So I've been helping her on it. Yeah, the judge basically just let the wife testify to everything. Didn't have them submit actual statements with actual things showing just the balance due on everything. That's all they submitted. They never submitted actual statements.
Which judge was this?
I believe it was Snyder Haas.
Really? Well, she's kind of new, and she's going to get reversed on appeal if she finds an extreme hardship on that data, right? And I think that without having detailed documentation, and the point that you had loan applications, a loan application is a place where somebody is going to go out of their way to be accurate and to list all possible sources of income, because that's how you qualify for the loan. So the motivation for filling out a loan application is different than the motivation for filling out a hardship redetermination application. So if you can get a loan application, you can use that and compare it against what they've submitted. They claimed more income on a loan application than they are in their C-35. You've got a discrepancy. And now
they're claiming they're $60,000 in debt solely due to workers' comp.
I mean, yeah, if you don't trim your expenses, then you might be. Yes,
well,
Brian?
And then it also comes to okay, so you're that much in debt. What have you been doing about it? And
right.
Especially considering if they're, if they are, they have to produce all that documentation of stuff prior to the expiration of benefits. So presumably they should have a budget surplus, while they're still getting the benefits. If they're still running a budget deficit and they're still getting their comp benefits, to me, that's on them. It's like, why is your financial house of cards a bloody shambles?
Well, and what I would recommend, Kim, is hopefully in your case that there have been ongoing demands for more detailed information that have been preserved.
Yes. Yep.
And so I would make that argument in the memo of law and insist that, in the memo of law that the judge be find that she's unable to make a determination that the application has to be denied because the information does not comply with the statute or the directions. They have not submitted sufficient documentation explaining the expense. Because in the absence of an explanation, the judge you could make two inferences, right? You could make an inference that the debt was accumulated due to bona fide expenses that we can't really complain about, or you could make the opposite inference that that's entirely frivolous spending that indicates that there is no actual hardship here, that it's self-inflicted.
And to that same point, the second case one I had with Larry Lindsay, I was actually talking to my wife about it because, as most of you might know, my wife's an orthopedic surgeon. So an orthopedic surgeon and a lawyer, our monthly expenses were actually less than what that couple was spending on stuff. And it's like, what are you doing?
Yeah, what exactly is it that you're doing? There's a couple of them. The question is, are you going and getting your an $8 coffee every morning, or are you using a coffee pod, or even cheaper yet, are you brewing a pot of coffee? There's a big difference.
Or like in one case, a woman spending $150 a month for hair.
That's a lot.
Yeah.
It's a lot for hair. We should not say any more. I'm getting some strange looks. There's some women in the room with me, and at least one of them is doing it.
No, but at the same time, there's a difference between, if you can afford it and, it's something you do to treat yourself, that's one thing. If you're saying, I'm so financially destitute that I need like emergency bailout help, and you're still doing that, then that's a horse of a different color. You might as well be eating lobster for dinner like 3 nights a week.
Well, Brian, I think we've run over time. It's 1:04. Unless we got other questions, I think it's time to call it an end.
Thanks for putting up with me and our little spiel here. If you have questions for either of us later, our emails are up there. And as always, if you got any questions, I'm sure anyone at our firm will be glad to help you out.
Thanks, everybody. Remember, don't get angry, get mad.
Bye, everybody.
Take care.
Thanks for all the great questions, Kim. Thanks, Mark. Excellent questions and great claims handling. Asset searches in advance.